I'm Drew Stevenson, and this is a lecture for my administrative law course about the case, the Federal Election Commission v. Akins, a United States Supreme Court case from 1998 about standing to sue and injury in fact. Now, the basic doctrine of who has standing to sue is pretty straightforward. There's three prongs: injury in fact, causation, and judicial redressability. And then we have some cases from the Supreme Court unpacking those different, or fleshing out those different components. So for example, Lujan versus Defenders of Wildlife said an injury in fact has to be concrete and particularized, and either actual or it already happened or imminent, about to happen. But when we get into court in real life, the standing cases are not so simple. They get complicated very quickly, especially when we have an association or group of people who are trying to challenge an action by a regulatory agency. So these aren't just traditional tort claims by a wronged plaintiff against a defendant. They are challenging a governmental decision by some government regulator. So let's look at what happened in this case. Our main takeaway here is, in case you lose interest, is in this case, the court granted standing to a group of voters who wanted to challenge a decision by the Federal Election Commission, or FEC. Now, the FEC, what had they done that these voters wanted to challenge? They had decided that a certain special interest group that's called the American Israel Public Affairs Committee, or AIPAC, was not a political committee or PAC under the Federal Election Campaign Act. So you may have heard about PACs and super PACs that raise a lot of money and then give that money to candidates who are running for office who agree with their views. And that was the issue in this case. And when we talk about these PACs, we need to talk about the statute. And the Congress had enacted a law called the Federal Election Campaign Act to fight corruption in elections. And among other things, it imposes really extensive record-keeping and disclosure requirements on political action committees, or PACs. Super PACs are just basically really big PACs. And in other words, if we have a lot of money bankrolling elections and campaigns, you have to disclose where that money's coming from and who you're giving it to. And that's what's the sticking point in this case. Now, who decides what counts as a PAC? Are you a PAC? Well, the FEC decides who's a PAC and who isn't. And now let's talk about our plaintiffs here. Akins is our named plaintiff, but he's representing a group of voters. And this is James E. Akins, who was formerly the U.S. ambassador to Saudi Arabia, who knew a lot about Middle Eastern politics and international relations, and was very concerned about AIPAC's activities in U.S. elections. And so Akins and some other voters filed a complaint with the Federal Election Commission alleging that AIPAC was in fact a PAC and had violated federal election laws because they weren't making these public disclosures of where all their money was coming from and where it was going. And that's what they mostly wanted. They weren't trying to get rid of AIPAC or ban it. They just wanted the FEC to designate AIPAC as a PAC, which would in turn force AIPAC to make the required public disclosures about who their donors were and their campaign expenditures and their fundraising income and so forth. And the FEC had dismissed this complaint. So the plaintiffs then sought judicial review of the FEC's decision. And the FEC said these people lack standing because the voters are in the same situation as all other voters and taxpayers. And basically, they're not harmed individually or personally by the FEC's decision. Maybe the FEC's decision is wrong or bad public policy, but there's nothing about these voters, they said, or these individuals that give them some sort of special interest in the case. Now, please note for my students, regarding the merits of the FEC's decision itself, the court just remands the case to the FEC. So the court doesn't really wade in at all into the question of whether AIPAC is a PAC or should have to make these disclosures. They're really only talking about the narrow question of whether Akins and the other plaintiffs have standing to sue. So let's talk about the holding. the Supreme Court analyzes standing here on two prongs. They call it prudential standing and constitutional standing. And unsurprisingly, constitutional standing is what you probably learned about in your first year constitutional law course. And in administrative law, we talk about that and something called prudential standing. And we have a lot of Supreme Court cases about this too. And a lot of them are split opinions, a divided court. So the court here is 6-3, and they said that the plaintiffs actually did have prudential standing. Why? Because the statute allows individuals to file complaints with the commission, and it allows those individuals aggrieved by an FEC decision to seek judicial review. In other words, we have some standing that we can derive from the Constitution's case and controversy clause, but the court is recognizing that Congress can sort of create standing by creating a cause of action for certain individuals, and that's what has happened here. The constitutional standing question in this case was whether the plaintiffs had a particularized injury in fact, or if they were merely alleging generalized grievances like that were abstract and basically shared by everybody else in the public. Now, the court here, this is a very important part of this decision, held that we don't look at just how widely shared an injury is. We look at how sufficiently concrete it is. So even if it's a widely shared injury, and normally you can't sue for something that doesn't affect you any more than everyone else in America. But the court here is saying if it's sufficiently concrete, it could still count as an injury in fact. I pulled out a quote for those of you who like to highlight in your case books. That's kind of the crux of the case or the crux of the holding. We conclude that the informational injury at issue here, directly related to voting, the most basic of political rights, is sufficiently concrete and specific, such that the fact that it is widely shared does not deprive Congress of constitutional power to authorize its vindication in the federal courts. Now, what's an informational injury? This is the requirement that groups that are raising millions and millions of dollars and then giving that money to candidates running for elected office would have to make that information public, tell people where the money's coming from and where it's going. And they're saying that that's a specific enough concern and related to the voting rights and election outcomes that we could at least say that Congress has the power to create a cause of action, which then will imply standing under that. So where does this leave us? Well, it seems that what made the injury in Akins more concrete than in some other cases where the court denied standing was the statute. So when you're looking at standing cases, don't just look at the plaintiff's injury and causation and redress, but you really need to look at the statute, especially if it's challenging the actions of a governmental entity or like an agency or commission or board. And so here, Congress's determination that a voter's interest in PAC disclosures should be a legally protectable interest. And therefore, so Congress had decided to make this legally protectable, and therefore the people who want this information have standing to sue. And that concludes our lecture about the Federal Election Commission, the Akins.